Okay, well, welcome to NJBIA Human Resource Council meeting, Managing New Workplace Considerations, brought to you by Connell Foley, NJM, Investors Bank, Association Member Trust, and the NJBIA HR Support Center. I'm Alice Gens, Chief Operating Officer and CFO of NJBIA, and with us today is Michael Shadiack of Connell Foley. Today's presentation is being recorded and will be emailed to you tomorrow along with the PowerPoint, so be on the lookout for those. I'd like to draw your attention to the chat box. Michael will be happy to take your questions, so get them in as they come to you via the chat section. This presentation is qualified for 1 CLE and 1 SHRM credit. If you'd like to receive credits for today's presentation, please reach out to Jasmine Garrett by email with the codes from the presentation. Jasmine will enter her information in the chat now. After today's presentation, we'll have 20 minutes or so to network with the speaker. And so now, I'd like to welcome Michael Shadiack from Connell Foley. Mike?
Great. Thank you, Alice. Good morning, everybody. Thank you so much for joining us today. I do appreciate your time. So today we're going to talk about new workplace considerations, given the situation that we're all been facing for the last year, and a lot of laws have come up and a lot of new considerations. So we wanted to talk about what those were. So just a little bit about me for those I have not yet had the opportunity to meet yet, either virtually or in person. My name is Mike Shadiack. I am the chair of the employment law group here at Connell Foley, and our practice is devoted solely to representing and supporting businesses. And a big part of that is helping them with their compliance efforts on their day-to-day personnel issues. And the things we're going to talk about today are those that come up most recently and really all the time. We're getting the calls and the emails. So I thought, why not put a program together that addresses a lot of these concerns that most employers share these days. So let me start by sharing my screen. I'm going to bring up the PowerPoint. Let's see. Okay. All right, great. Can everybody see that screen? Alice, can you see the PowerPoint?
Yes, I can.
Excellent. Okay, so as mentioned, we're going to talk about new workplace considerations. And of course, the one that's on everybody's mind is the COVID-19 vaccine. Now, we could spend the entire hour just talking about the vaccine, and I don't want to do that. What I want to do is hit the high points. I want to hit some of the things that a lot of our clients have been asking us about relative to the vaccine, and it's also going to help set up the other items that we'll be discussing today. So when we talk about the vaccine, the question that every employer has been asking is, can we as an employer mandate the vaccine? Now, the answer to that question is actually yes. The EEOC came out with guidance back in December 2020 to answer that question in the affirmative. However, I think as we all know on this call, nothing is ever that simple and straightforward. So there are a lot of considerations that go into that question of can we mandate, should we mandate? So those are really two different questions. Can we mandate? Yes, we can. But what are the legal considerations that go into that decision by management? So if the employer puts a mandate in place, the employees may object, and they may object on a number of bases. So for example, someone may say, I'm afraid of needles. I don't want to get the vaccine. Someone may say, well, you know, this was only approved under an emergency authorization by the FDA, so I'm not really sure about the science behind it, and I really don't want to put that in my body. Others may just say, hey, I don't want to stand in line if I can't get an appointment with 400 people on a cold day in March. All right, so there are a lot of reasons. Are any of those reasons legitimate reasons to object? No, they're not. But are there legitimate reasons that an employee can object? Yes. And there are two in particular. One is if they have a medical issue, a disability, that could be justified by way of documentation from their primary physician. That is a very valid basis to object pursuant to the ADA. What's the other reason? The other reason is based on a sincerely held religious belief that also can be supported potentially by way of documentation. That has to be accommodated as well under Title VII and New Jersey law. So those are two very valid reasons for an employee to object. So let's just play this out. Let's say an employer puts a mandate in place. An employee objects, either on the basis of an accommodation issue because of a disability or because of a sincerely held religious belief. What's next? What is the employer to do? Well, by law, the employer must engage that employee in the interactive process. What is that? Well, the discussion with that employee. Let's find out the reason for the objection. Let's find out what it's based on. Let's talk about it. The employee can be requested to provide documentation to support the request or the objection. And what the employer then needs to do is to figure out, can we reasonably accommodate this individual's request without it creating any undue hardship for our company, for our practice, for our organization? And that's a dialogue with the employee. It may be several sessions of conversations with that employee. But at the end of that conversation, at the end of that interactive process, what the employer has to determine is, can we accommodate this person if they're going to be unvaccinated? Maybe we have to allow them to work from home, which sets up what I'm going to talk about in a few minutes. Maybe they have to wear 2 masks and a face shield if they're not going to be vaccinated. Maybe we need to separate them from others in the workplace where they'll be more isolated so that they're not interacting with others. Not really ideal situations, but these are all the considerations. Now, let's say the employer decides we can't accommodate this person. What can we do? Well, the law says that if that person presents a direct threat to your other workers, you can exclude that person from the workplace. How would you exclude someone in that scenario? 2 reasons. 1, you terminate them. They're an at-will employee, okay? No contract. They're not a unionized employee subject to a collective bargaining agreement. They're at will. If you get through that direct threat analysis and you determine they do pose a direct threat, they could be terminated. What's the other reason or solution? Remote work. So you're excluding them from the workplace proper, and they would have to continue to work remotely if their job allows for that. So when you say, well, Mike, what is a direct threat? What are the factors? The EEOC gives us those 4 factors. 1, the duration of the risk that would be posed by the unvaccinated worker. 2, the nature and severity of the potential harm that that person may present. 3, the likelihood that the potential harm may occur. And 4, the imminence of that potential harm. So I've had a lot of discussions with employers over the last couple weeks about this direct threat analysis as it relates to unvaccinated workers. And what I'm hearing are 2 different sides of the coin, if you will. Some employers will say, hey, wait a minute. If 95% of my workforce is going to be vaccinated voluntarily, and you have 5% who don't want the vaccine on whatever reason, basis, justification, that 5%, they pose a threat to everybody else. I can't have them in the workplace. Okay? Because remember, even if we're vaccinated, the science is telling us that may not mean we can't carry the virus to others. So if someone else brings it into the workplace, that's a threat. Okay, understand that position. The other side of the coin, we've had these employees potentially coming into the workplace ever since the pandemic started, maybe on a rotational basis, maybe every other week, but a lot of employers have had their employees coming in unvaccinated. Now, in my hypothetical, 95% of your workforce is vaccinated. I think it's hard in that scenario for an employer to say that that 5% now all of a sudden poses a direct threat to the workplace. Well, didn't they pose a direct threat to the workplace over the last year? And you had them coming in when no one was vaccinated? Interesting other side of the coin. I don't have the answer to it. I think every employer really needs to look at that, look at its business, look at how closely their employees work together in close proximity. What type of work do they perform? And these are challenging questions for employers to which I don't have any definitive answer. It's really going to be the employer analyzing both sides of that coin. So just to set up my next topic here is, if you get through that whole analysis, you can't accommodate them, you determine there is a direct threat, and you're going to exclude that worker, one thing you then could do is a remote work situation for that person. So what I want to talk about next are these, what I call telecommuting policies and a remote work location safety checklist. Because what I found with a lot of our clients that we've been helping, they were kind of flat-footed when the pandemic hit to allow people to work from home. They didn't have policies in place. They didn't have the necessary procedures set up, and it was learning under fire, so to speak. So we've been helping a lot of clients with these policies, with these remote work safety checklists throughout this whole time. So I want to mention some things that we've learned during this process that employers really want to have in place. So some employers have been completely remote all along. Great. Some employers have had people working, maybe on an alternating basis. Some employers may have had everybody back. But now they're thinking, hey, these unvaccinated folks maybe pose a threat. We have to go to a remote work situation possibly for them. So I just want to highlight some things here. So as we say, this policy is very flexible, and it would complement either a phased-in return to work plan to reduce your workplace density, or if folks are needed to care for their children because school is closed and they're engaging in virtual learning, or because someone opposes being vaccinated for COVID-19. So a couple bullet points I put here that I think are very common that employers did not think about relative to this issue. Number one, you want to require the employees to utilize up-to-date antivirus software. Keep those virus definitions updated and run regular scans to ensure that when they are accessing your confidential business information, that is secure. It's not going out to people who shouldn't have that information. And it's hard to do when you're remote and they're remote to really know, are they taking the appropriate steps to safeguard this data? Number two, ensure the employee has the adequate internet capability, the equipment that's needed to do their job efficiently. What our clients learned is a lot of folks really didn't have equipment at home for whatever reason. Maybe they don't have a home computer. Maybe they rely on their phone. Maybe they don't have a printer. Maybe they don't really have internet connectivity for whatever reason. So just to say to folks, you're going to be working remotely, how do we know they're equipped to do that? Right? We want to reserve our right as a company to do an audit, to maybe even go into their home to make sure they have the proper equipment, the proper virus protection, the proper internet speed. They're taking the proper precautions. They're creating a safe working environment for themselves. So reserve your right as management to do that. The big one I like are these accessibility requirements. Have any of you been in a position where the employee's working remotely? You send them an email, you leave them a voice message, you have a question, and you're expecting a response in a timely manner. Maybe that answer is going to set a chain of events in motion, and you're waiting for that answer, and you're waiting, and you're waiting, and you're waiting. Is that acceptable? Is that what you're waiting for? Whenever the employee gets around to it because they're working remotely, or are there expectations as to how quickly that person's going to respond? So for example, in the policy, we can say, if we send you an email, if we send you a message, a voice message, the expectation is, unless you're on a break time or your lunch, you will respond within, and give them a time frame. 5 minutes, half hour, within the hour, right? Hold them accountable. Right? This is not a free-for-all just because folks are working from home, and we've heard employers' frustrations over this last year of people just not being very responsive. Okay? And always reserve your right as management to discontinue the work from home arrangement. This may not be forever, even if you're having to work from home as an accommodation. Well, who knows what the future holds, right? Maybe things will change, and now you're going to call that person back into the office. So don't let the employees think this is a permanent situation, okay? And always in your policy, reinforce your at-will employment relationship with that individual. Okay, what are some other things that we should be thinking about here as to a telecommuting work situation? Remember overtime, okay? The employees must be recording their hours worked. They have to. because you as the employer have to have time records of the time that these individuals are working remotely. So it's not again, free-for-all. It's the same standards as if they were in the workplace. Now, if this is a non-exempt employee that's working, anything over 40 hours in that work week has to be paid as overtime. So what we've heard from a lot of our clients is people are actually working more when they're home. They don't have to be in the car commuting potentially for an hour or two a day. They're working while they're watching television or with making dinner or who knows what they're doing on their own time. They're working. And if those hours would put the non-exempt employee over 40 hours, that's overtime. So we have to make sure they're doing their record keeping, they're submitting their time records, and whatever their standard break time is, including that lunch break, that they're taking it. And they're not just working through lunch while, having a granola bar or something, and they continue to work because now that's hours worked. Something to be very, very careful of. I anticipate we as employers are going to see a lot of wage and hour claims brought by workers who say, I was working 50 or 60 hours a week and I was never paid the overtime. So something to be very mindful of. And we want to make sure they are creating and maintaining a safe offsite working environment for themselves, and obviously reporting any injury that may occur at home. So I wanted to spend a moment about some considerations as to an offsite work location that is a safety checklist. So why are we going to do this? I had an employer say to me, why would we, Mike, what's the relevance here? Because we understand if an employee gets hurt while working from home, that's work, right? So potentially that may lead to a workers' compensation claim. And the employer said, we understand that, but isn't workers' comp a no-fault insurance policy? So how does this factor into that at all if it's a no-fault insurance? And my response to them was, just because it's no-fault insurance doesn't mean the employer has zero defenses to any type of claim that may be followed or filed, I should say. And one of them is, if you have a safety policy, if you have safety protocol that must be followed by the employees, and that employee willfully violates that safety policy, that's a defense for that employer. So in my view, why not have a policy that A, could hopefully help make sure that your employees have a safe work environment, and B, if there is a workers' comp issue that arises, at least provides that employer some defense that, hey, we're a responsible employer. We have this checklist in place. We want to make sure that they're creating a safe and maintaining a safe working environment. And here is the checklist that we use. So in the interest of time, I'm not going to read what's on the screen. You'll see it and you'll have the PowerPoint, but these are some of the things that we would want to include on a checklist. I actually brought with me a sample here. This is a sample of a home safety checklist. You may not be able to read it, but I want to show you it is detailed. In fact, it goes on to a second page, and we're going to ask the employee to answer every question, answer yes or no, and then they're going to sign off on the bottom. Okay, so now we have a signed document for that employee certifying that they are maintaining that safe workplace. And in my opinion, that's important for all the reasons discussed. Now, when we're talking about COVID, it's always important that every employer have a COVID policy. And I would hope by this point, most employers do, because we've been going at this for a year now. But many employers, I realize, still don't have policies that are in place and that they follow, right? And we all know that. It's one thing to have a policy. It's another thing to actually follow it and make sure that we're adhering to it and the employees are compliant. So what I wanted to talk about a little bit are some of the key components to a COVID policy, so that if you don't have one in place, this will be a good roadmap for you. If you do have one in place, maybe there are some things that we'll talk about along the way that you may wish to include. So I want to start, though, with Executive Order 192 that Governor Murphy signed back in October of last year. And the order applies to every business, every nonprofit, every governmental and educational entity in the state, and imposes strict requirements in order to curb the spread of the virus. And it's a very important executive order. I strongly encourage every employer, if you have not printed out a copy of this and read it, I would recommend that you do that. I think it's very helpful. I think they provided a lot of guidance and requirements. So I just bullet pointed a few of those requirements here. One of them is the social distancing requirement, that wherever possible, all in-person employment settings must enforce that 6 feet rule that we're all now so accustomed to. If, however, the nature of the employee's business or profession precludes compliance with that mandate, each employee has to wear a mask, okay? Or you have to put up some barrier, okay? This isn't just, this would be good to do. This is a requirement. And it still surprises me that a lot of employers are not doing that, or maybe you're not aware of the requirement. The next is the face mask requirement. Employers must require employees, patrons, clients, and all visitors to wear a face mask. Right? Employers must supply the face mask to their employees at no charge to those employees. Okay? And this applies to everyone coming into your workplace, including any visitor that you may have. Again, it's not a recommendation, it's a mandate. Next, should an employee refuse to comply with the face mask requirement because they cite some medical issue? And we've had that. Many of our clients have had this issue come up. It restricts my breathing. I have asthma. I have seasonal allergies. This mask is not working for me. What am I to do? Well, what the employer has to do is engage in that interactive process with that employee and see what accommodation can be offered. Maybe instead of a mask, maybe it's a shield, that they wear. Maybe there's other options that are available, and you always want to engage and include that employee and their physician in that discussion. How about handling of known or suspected cases? The law says employers must immediately separate and send home that employee if they appear to have symptoms. It's not a recommendation, it's a mandate. Okay? The employer must also promptly notify all of the employees if there is a known COVID diagnosis, but you got to maintain the confidentiality of that infected employee. So I hope by now every employer should have a form notice. So when you're aware that someone is tested positive, you can get that notice out to all employees. Some of our clients say, does it have to go to all employees, even people who are just working remotely and never came into close contact with that person? Well, look, at a minimum, it should definitely go to every employee that may have had close contact with the infected person. Okay. On the safe side, send it out to everybody, but never mention the individual's name. You do want to mention the last time the person was in the office or in your work location, what the date was. Last time they were here was Monday, March, such and such, but never, ever disclose their name, as that is protected by the ADA. And it also says the employer must, okay, again, a mandate, disinfect the worksite in accordance with CDC guidelines if someone was learned to be infected with the virus. Okay. It also goes on to talk about daily health screenings. Employees shall, again, not to repeat myself, but to repeat myself, not a recommendation, a mandate, that employers must conduct daily health checks of all its employees. If you have multiple shifts, every shift you have to do a daily health screening. And we're going to talk in a little bit about what kind of form those health screenings could take, but they have to be done. So you say, oh, come on, we're not in compliance with these things. What could be the penalty? What could the state do? Well, I bullet pointed that for you here on the screen. The order provides that any employer that fails to adhere to the protocols outlined in the order or to any subsequent requirements that are issued by the State Department of Health is subject to, among other actions, closure by the Department of Health pursuant to state law. So again, nothing to fool around with, something to definitely be aware of. I would Google New Jersey Executive Order 192, make sure your management team is well aware of it and that the company is complying. Now, you say, how do we comply? Again, it comes back to your policy. You need to have a COVID policy and make sure everyone's aware of it and is following it. So the policies that we have been preparing for our employer clients basically they have 3 sections to them. The first section is on health screening. Okay? What does the employer do? What is their health screening mechanism? How is this conducted? It's very important to set that forth. So a couple things about these screening limitations. The EEOC does permit it based on the danger to others that the virus presents, and that's the rationale. So the health screening is certainly permissible and has been throughout the entire pandemic. You want to do this in a non-discriminatory manner and always maintain the confidentiality of that information. So what kind of screening can we do? Well, there's off-site and on-site. So off-site screening, there are phone applications. I'm sure many of you are aware. You can look them up on your phone on whatever platform you have, and there are apps that could be utilized by the employer to have people answer questions before they come to work each day. There are daily email and text survey health screening protocol. That's what we use here at my office. There's a vendor that we have signed on to. Actually, we did it last March. Every morning, every employee gets an email. And in that email, there are a series of questions with checkboxed answers under it. We select the appropriate answer for our specific situation, and we hit submit. Right? We then get a text message back saying whether we are cleared to come into the office or not. All that information is sent directly to our HR staff. We don't want it going to a manager or a supervisor. Why? It's confidential medical information. It has to go to whoever handles that information within your organization. On-site, okay? If we're going to do it on-site, people are coming in, we're taking temperatures, we're asking them questions. The advice we're giving is have it as close to your entrance to your workplace as possible. Why? Well, what if that person has a high temperature? You want them to turn around and leave, right? If they're already into your office, that's no good. They've already potentially maybe exposed people, walked by someone, talked to someone for 5 or 10 minutes in the hallway, maybe while waiting online. So you want this as close to your entranceway and preferably before they even step foot into the workplace. We talked about privacy, very important. Who is going to be seeing the temperature readings? You're going to have a member of your staff do that? Well, if so, they are now exposed to that person's temperature medical information. So is this someone in HR who does these screenings? Do you bring someone in from the outside? So for example, there are a lot of temporary placement firms that are sending nurses, nursing students, others who are not directly employees of the business to the workplace to do these screenings at the time the employees are coming at the start of their day or at the start of their shift. Something to consider, okay? And then the methodology. Is it temperature checks? Are we doing a visual inspection if we're doing an on-site screening? And then what do we do with that information? Who is conducting that screening? Very, very important for the employer to consider. So if you're going to do a questionnaire, these are some questions you may want to consider. You may already be using a questionnaire. You may want to check some of these questions to see if they're included in what you're presently asking. Okay, so the screening protocol. If the person is negative, they check out all the boxes, no fever, no chills, such and such, obviously they can enter the workplace. If they're positive, we're going to require that person to leave the workplace. Is that just a policy of the company? No. As we just went over, Executive Order 192 mandates that you have that person leave your workplace. So there should be no fear that, well, if we do that, can this person say that we are somehow discriminating against them because they're sick or retaliating against them? In my view, we're following state mandate, which says you have to excuse that person from the workplace, okay? We're going to issue that positive notification letter I spoke of a couple minutes ago. You're going to do your contact tracing. So reach out to that ill employee and find out, who have you been in close contact with over the last couple of days? Give us some names. We need to know. We need to specifically notify them to get tested. You're going to clean that work site. How are you going to do that? Well, ideally, professionally. Some of our clients went out and actually bought a fogger machine and they're doing it themselves. Okay, that's better than just using some Lysol wipes. But you probably want to have it professionally cleaned, especially if someone has tested positive. And now we want to look at that person's leave of absence rights under the various federal and state laws, and we're going to talk about that a little bit later. Okay? So just a little bit on OSHA. OSHA came out with some guidance, January 29 of this year. Guidance, recommendations, okay? They're advisory in nature. They are not mandatory. So they came up with some guidance, and they call them the Protecting Workers Guidance on Mitigating and Preventing the Spread of COVID-19 in the Workplace. And the guidance contains recommendations as well as descriptions of mandatory safety and health standards. They're only advisory, but I think they're excellent. It's a pretty lengthy document. Again, a recommendation, I gave you the website here at the bottom of the screen. My recommendation would be print it out, read it. Very helpful, I think well thought out guidance. And it provides additional detail on what employers really should be doing when sending somebody home who may be infected, implementing social distancing measures, barriers in the workplace. How do we suppress the spread? How do we clean the office properly? And then in some environments, proper ventilation is very important. So how do we improve upon that if it applies to your business? They give very good guidance, and I would recommend to everyone to check that out. Now, we are offering a Cle credit for today's program. There will be 2 codes. You can see the first code here at the bottom of the screen in red. First Cle code, HR 0318. Again, for those who may just be listening without the benefit of the slides, first Cle code HR 0318. So, second part of a COVID policy is what we call the containment section of the policy. Containing the virus. We want to prevent and reduce the transmission of the virus in the workplace. We want to establish a prevention program, as OSHA speaks of in their advisory guidance that I just mentioned on the last slide. And this is all obviously to create and maintain a healthy working environment. And it's going to talk about things about hand washing, following CDC guidelines, coughing and sneezing etiquette, cleaning and disinfecting, and also sharing of tools or equipment in your specific workplace. Everyone's different. I mean, whether you're a law firm versus a construction site, you're going to have different protocol as to the equipment and tools people are using, and how are you ensuring that it's safe and it's cleaned between each use. Personal protective equipment. Are we going to require it? Are we going to recommend it? Or are we going to permit it? It's based on each employer. But remember, if you're going to require it, the employer has to pay for it, right? That's Executive Order 192. Social distancing will also be addressed, okay? You have to remain 6 feet apart, stagger those working hours in the meal breaks, reconfigure workspaces and meeting rooms, remove chairs if you must, tape off chairs. I went to an appointment the other day, and every other chair, they actually had tape across it. Do not sit here, okay? These are the things we need to do to ensure people are complying. Limit your in-person meetings and really look to video platforms more and more as we continue with the pandemic. Self-monitoring, making sure people are telling you if they express any symptoms. A great reason for having that survey that folks fill out every day, so that if they are expressing any of those symptoms, your HR department or whoever handles HR in your organization will know about it. And have the same policy apply to your visitors. You may want to have a visitor health screening questionnaire. Before they even come to your office, send it out to them, email it to them. Please complete this, come prepared in the morning with it completed. In my office, we actually have a stack of them at the reception desk. As the person comes in, they clean their hands, they fill out the sheet. Right? We don't even call the person they're here to see until that sheet is completed. And then how about your deliveries? A lot of our clients have just designated a separate drop-off location where the person, right, in the good old days, the delivery person would come in with their hand cart and go right to your supply room and drop them off. No longer, right? Maybe there's a drop-off location. Maybe they just leave it by the door. But I would work those things out and continue that practice into the foreseeable future. The third section of your policy is going to be dealing with travel. Now, can we as an employer restrict someone's personal travel? Can we tell someone, you can't go to Florida during your child's spring break? Can we tell someone that? No. We have liberties. We can't handcuff somebody and chain them to their workstation. They have liberties to go. Can we restrict our business travel? Sure, because that's all in furtherance of their business goals and objectives and their responsibilities. We as the employer can control that. So that's what we want to really control by policy. So you want to have a uniform application to all employees and really consider limiting that business travel to only that's really still essential, can't be conducted any other way, including by video, like we're engaging with today. And any travel would have to be approved by management, okay, in writing. Again, another good suggestion a lot of businesses have implemented. Now, we talk about a quarantine period when they return. And I received this question, without exaggerating, probably 500 times during the pandemic about what are the quarantine mandates? What is required in New Jersey? How do we comply? Well, the CDC set forth quarantine recommendations. New Jersey has set forth a travel advisory, not a mandate, an advisory. And if you remember, when this New Jersey, Connecticut, and New York's governors came up with this concept many months ago, maybe last year at this point, Connecticut and New York's governors passed an executive order mandating the quarantine at that time. New Jersey's governor never did that. So it's always remained in New Jersey a travel advisory. So how do employers deal with quarantine issues and what their policy will be? In the COVID-19 policy, you want to have a section on travel. And what that's going to do is it's going to tell your employees what your policy is when they return from travel, whether personal travel or business travel. Do they need to quarantine? For how long? If they're a non-exempt employee, do they get paid if they can't work remotely? Let's say they work on a production line. They can't work remotely. And they're a non-exempt employee, and you make them stay at home and quarantine. Are you going to pay them for that? Well, that's a policy of the business. They don't have to get paid if they're non-exempt. So your policy should explain that, because I'll tell you, it really will inform your employees' decisions whether they want to work, travel or not. We had one example of one employer. The employee went to Florida on vacation, came back, and the employer said, okay, but now you need to quarantine for 10 days, 2 weeks. The employee went nuts. So what do you mean? I can't be out of work for 2 weeks without pay. I have bills to pay. The employer said, you should have thought about that before you left. The employee's response was, well, there's no policy in place. We didn't know. I didn't know that. I wouldn't have gone on this trip if I knew when I came back I had a quarantine. And, I see it from both perspectives. That's the benefit of a policy. It will be clear, it will be explained, and it will inform people's decisions, especially as we're coming up into the summer months and people are anxious to get back out and travel potentially. Now, moving on, I want to talk about some wage and hour considerations, because these are things that have come up quite a bit to this day from our clients. So I've talked a lot about exempt versus non-exempt. I just want to make sure we're all on the same page, because this is something that even the most savvy folks oftentimes get tripped up on. So a lot of people think employee is paid a salary, that means the employee is exempt. And that's not the case. Okay? The exempt status is not solely based on the fact that the person is paid a salary or their job title. Somebody can be called the Grand Chief Poobah, but what they do, the duties, actually make them non-exempt. So titles alone mean absolutely nothing. Being paid a salary alone means absolutely nothing. Instead, if you look at the other column on my screen here, the exempt status is based on A, they are paid a salary. 2, that salary meets the threshold as established by law. So under federal law, it's $35,568 a year. If someone fits under the highly compensated employee exemption, that's $107,432 a year. And you also have to consider the state thresholds. Now, although New Jersey follows the federal that I just spoke of, New York has its own set of guidelines, its own set of salary expectations that would have to be met and thresholds in order for that person to be exempt. You got to be mindful of that if you have any New York employees. And then the third part of the analysis, you have to look to their job duties. What does the person do? What is in their job description? Okay. And what we have to do is marry that to the exemptions. And you say, well, where do I get the exemptions? So a little practical tip, if you Google FLSA, Fair Labor Standards Act, fact sheet 17A, it's going to give you all the exemptions, and it's going to give you the tests for each exemption. The person's job duties have to meet those factors. If they don't, the person is not exempt. So this is important when we're talking about who is quarantining, whether they will be paid or not. And for overtime purposes, if that person's working over 40 hours in a work week, whether as an accommodation or otherwise. So a couple other wage and hour thoughts with that in mind. Furloughs. Last year, this time, this was probably the hottest topic in employment law. Employers were having to furlough their employees. But you know what? A year later, that's still a topic of conversation, and it remains a conversation topic about unvaccinated workers. Could they be furloughed? Well, there are legal considerations that have to be considered about a furlough. And just to back up, some folks may say, what do you mean by a furlough? A furlough is the person's put out of work for a period of time, typically unpaid. They're not fired, they're temporarily furloughed. Okay? They're expected to be brought back at a time in the future. Well, a couple things. We have to consider the person's contract. If they have a contract of employment, because that contract is going to set forth their level of pay, it may set forth their working arrangements, number of hours they work. We don't want to walk into a breach of contract situation. We also have to consider the person's union status. Okay? The union folks are covered by a collective bargaining agreement. We can't just furlough union workers. That's a discussion that we have to have with the union about the effects, the impact a furlough would have. What about the person's immigration status? You have to think about it. We can't just say our entire workforce or these 50 people we're going to furlough. You also have to think of what if any of those people are here on a visa? Because if they're here on a visa, then as part of that visa application process, especially if it's an H-1B, the employer had to file what's called a labor condition application with the U.S. Department of Labor, which identified and certified to the person's work location, their hours of work, the wage in that region, and the person's salary. If the employer furloughs someone who's here on a visa, technically, those provisions no longer are applicable because they're not getting paid. And what that does is it jeopardizes their visa status. The employer has to report to the government, and unfortunately, that person will have to leave the country. I believe they have a 60-day window to either get things rectified or they have to leave the country. So these are things that have to be considered. You should be speaking with an immigration attorney about these issues. It's one of the reasons I'm thrilled that we now have a corporate immigration practice at the firm as of this year. So they're fielding these questions and helping employers through that. We also have to consider their non-exempt and exempt status. Okay, if they're furloughed, they're non-exempt, you don't have to pay them. They're furloughed, they're exempt. If that person performs any work in that week, they have to be paid for that week. So even if they're checking their emails or they're making a phone call or answering a call, they have to now be paid for that week. So their status is important. How about reducing pay or hours? Can we do that? You could, provided there's no contract in place, provided they're not on a visa that sets their salary level. Other than that, yes, you can change their salary prospectively only. Can't do it retroactively, only going forward with giving the employee notice of any change. Some other special considerations for your exempt employees. Okay, you can reduce their base hours with a commensurate decrease in their salary. Again, with the same caveat that they're not subject to a contract of employment and they're not here on a visa. You could do that even if they're exempt. You can only do this for bona fide business reasons, and you have to consider the impact on that salary threshold for the exemption. Because remember, if that person is just on the cusp of that $35,000 figure to be exempt, and you reduce their hours in pay and they fall below that, they're automatically non-exempt, automatically non-exempt. So again, these are easy decisions to make to say, well, we'll just reduce their pay and reduce their hours worked. What employers often don't think of is what is the trickle-down effect of that? So very interesting issue that always has to be considered by management. And these furloughs of an exempt employee can be done, but they can't be frequent, as the law explains. Okay, some other wage and hour thoughts here. If the person's working remotely, all the wage and hour laws apply. There's no difference. There is no separate set of rules because someone is working remotely. Same laws apply, as I've talked about, especially as to overtime. As I mentioned earlier, but it's worth repeating, you must be tracking your employees' hours worked. Whatever mechanism they used beforehand, timesheets, maybe an app, whatever it may be, you have to know the hours they're working. You have to maintain those records for 7 years, just as if they were in the workplace. Okay. I mentioned overtime. Again, it's worth repeating. This isn't an accident. I put this in here several times on purpose. If they are a non-exempt employee and they are working more than 40 hours a week, okay, they have to be paid overtime. Every work week stands alone. Employers say, well, wait a minute, we're on a 2-week pay cycle, so we look at it every 80 hours. No, every work week stands alone in the eyes of the law. So you're looking at it at a 40-hour work week. Okay. Can you say to a non-exempt employee, look, John, we're not going to give you overtime, but we'll give you comp time. We'll give you comp time. You know what? Take the day before the next holiday off, or July 3rd, take the day off. Can't do that with a non-exempt employee. They have to be paid the overtime. They can't get comp time. An exempt employee can be given comp time. Hey, John, you're working the long hours. We know you were here till 10 o'clock the last few nights working on that project. You know what? Leave at 12 on Friday. Can you do that? Sure, for an exempt employee. So for your non-exempt folks, the only wiggle room you really have, as I say in the last bullet point, you have some flexibility, is with supervisory permission. In the same pay period, you could have people work some flexible hours, that non-exempt person. Let them leave a little sooner, just so they're not going over the 40-hour mark. That is permissible if it's within the same pay period that they're taking the time. It just can't be sometime in the future. Okay, your exempt folks, they must be paid the entire work week if they perform any work in the week. There are only some limited exceptions, and that's called the salary basis test. So another little practice tip I'd give everyone, Google FLSA, Fair Labor Standards Act, salary basis test. That's going to tell you the limited exceptions where you would not have to pay an exempt employee for time that they didn't work. I list 3 of them here on the screen. There are probably, give or take, 7 or 8. But if they're out for a personal reason, if they're on family and medical leave, and the first week and last week of their employment. So let's say the person leaves on a Monday, you obviously don't have to pay them that full week, right? If they start on a Thursday, you would pay them 2 days, not for the full week. So that's one of the exceptions. Okay. Tools and services may be needed to work remotely. And the one thing I want to point out here is, do we have to pay the employee for these things, to purchase these things? Do we have to reimburse the employee for maybe you have to buy a printer or a laptop or higher speed internet access in their home? Who's responsible for those costs? Well, number one, in my opinion, that really all should be in your telecommuting policy, so it's clear and it's upfront. But the other consideration is there's no law that's going to mandate the employer pay for those at-home tools or services, unless the cost of which will drop that employee below minimum wage. If it does, the employer must reimburse the individual for those costs. Okay, let's move on now to managing employees' leaves of absence. And I'm looking at my, off to the side here because I'm looking at my time. I know it's 11:50 and we're doing really, really well on timing so far. And this is our last segment of the formal program. I'm happy to answer questions. So managing employees' leaves of absence, and we're going to have a special focus for a reason on the New Jersey Family Leave Act. Now, many of you who have come to other presentations I've done, some of those have just been on managing leaves of absence, because gee, we could fill at least 2 hours on this topic. You'll remember this slide. And to me, this wraps up the entire discussion in a visual that I would ask everyone to remember. Because when someone needs to go out on leave, you really need to be thinking of the 2 railroad tracks. The railroad track on the left is how we as the employer are going to manage that person's leave. Railroad track on the right is when that person is on leave, is there any income replacement benefit available for that worker? Okay. 2 totally different concepts. So I'll just give you an example. Have any of you ever heard anyone in your workplace ever say, well, Mary's on short-term disability leave? Right? I actually can't see you, but I see some heads nodding. Right? Have you ever heard, well, John is on workers' comp leave? Right? I've heard people say it all the time. Both are incorrect statements because no one is on short-term disability leave or on workers' comp leave. You know why? That's railroad track 2. Those are benefits. They're not leave statutes. There's nothing in the short-term disability statute. There's nothing in the workers' comp statute that speaks to leave, because it's a benefit available to an employee who's already on leave approved by the employer. Okay, so let me show you what I'm talking about. How does someone get leave? You get leave from one of these things that I'm showing you on the screen. It could be your policy handbook, your handbook policy, I should say. Could be a reasonable accommodation under the ADA or the New Jersey law against discrimination. We're accommodating them with a leave of absence. It could be a statutory leave per the Family and Medical Leave Act, the New Jersey Family Leave Act, the New Jersey SAFE Act. Maybe they're taking paid sick leave, or maybe you're looking to what your company's precedent is in similar situations, and you're looking to those similarly situated employee considerations. And after doing that analysis, and again, it should be done with your HR professional, it should be done with whoever you use as an outside employment lawyer to work and to really think about these things and chart out how that employee's leave will be covered and approved, because all of these things you see on the screen have different criteria, different thresholds. It's not cookie cutter. So it really has to be well thought out and planned out. So once we know how this person's going to be on leave, then we can also inform the employee what benefits are available to them. So you see the red circle there. They're on a leave of absence from work. Depending upon the reason of the absence, there is a different benefit available to that individual. So if they're injured at work, they can apply for workers' compensation insurance. If they're injured not at work, or they become ill not at work, that's your temporary or short-term disability insurance. If they're caring for a family member, okay, child, after a birth, because they're off due to the child school being closed and they're caring for that child, that's the New Jersey Family Leave Insurance benefit. Obviously, if there's a break in service, that's unemployment. So what we have to think of, 2 railroad tracks. Why are they on leave? And let's document that in a letter to the employee. Let's explain the leave and also inform them in a paragraph in that letter what benefit they can apply for. Now, I always say to our clients, and we are very fortunate to work with great people. I know some of you are on the call today, and thanks for joining us. And they're all wonderful people. But what I always tell them is that railroad track 2 is not your concern. You care about your employees. You want to do the right thing. You care for them as people. I get that. But putting aside the human element, you don't control the right railroad track. First, the person has to apply for one of those benefits, and then it's up to whoever administers that benefit, the insurance company, the state of New Jersey, to grant or deny it. It's not the employer's concern. You have no control over it. You control the leave, that railroad track 1, and that's what we have to make sure we're getting right. So I want to talk a little bit about specifically the New Jersey Family Leave Act, because there are some changes here that I think a lot of employers often overlook. Everyone focuses on the federal Family and Medical Leave Act, and that's the first thing I always hear out of an employer's mouth when we're dealing with a leave issue, and that's fine. But remember, if you have less than 50 employees, the federal Family and Medical Leave Act doesn't apply to your business. Okay, so let's say you're one of those employers, or even if you are one of the employers that the law applies to, we always have to consider New Jersey's law. Now, New Jersey's law is the New Jersey Family Leave Act. What you'll notice, what's missing? The letter M. M stands for my medical reason. So as you know, New Jersey's leave statute has nothing to do with the employee's leave of absence for their own medical condition. It's only when they need leave for a family member. That's a great little tip to always think of. What's the difference between the federal law and the state law? The federal law covers your own medical as well as a family reason, right? It's the FMLA. State, it's just the NJFLA. So, a couple things to point out. This too, for years, only applied to employers with 50 employees. But as you see on the screen, that changed in 2019. And it applies now to every employer with 30 or more employees. So think about that. You really have to know what your employee count is. And they do that based on a 20 work week basis. For 20 work weeks in 2021 or in 2022, were you over that threshold? If you were, your company has to comply with the NJFLA. If you are a company that's growing, maybe the pandemic actually has been good for business. Maybe the product you sell or the services you provide, and you've added people. And you used to be a team of 15 and now you're 35. You have to know about the NJFLA because it applies to your business if you've gone over that 30 threshold for 20 or more weeks. And all your employees that work outside of New Jersey are included in that count. So if you have 10 people in New Jersey, 10 in Florida, and 15 in California, guess what? It applies, right? And employers often forget to count people outside of New Jersey. So what employees would this law apply to? They have to be with you at least 12 months. By the time when they're asking for the leave, you're going to look back 12 months. Were they with you as an employee? And did they work 1,000 hours during that 12-month period? If the answer is no, then they're not eligible for this leave. And what you would then look to is, do we have a policy in our handbook that would grant an employee leave to care for a family member? If you don't, then guess what? Then there's no basis for the employee to be out on a family leave of absence, okay? A couple things employers need to be careful of. An employee is considered to be employed in the state of New Jersey if, well, they work in New Jersey. Well, that's obvious. But the one not so obvious is the second. The employee routinely performs some work in New Jersey and the employee's base of operations or the place from which the work is directed and controlled is in New Jersey. So I'll give you an example. We have a client, their entire presence, their entire workforce is here in New Jersey. Okay? They have an employee who lives in another state. Let's call it Missouri. That person needed family leave and they inquired about their rights. Are they entitled under this statute to leave? The employer, which I was thrilled of, called me and didn't just go off their instincts and said, well, the person's in Missouri. They're not here in New Jersey, so they're not eligible, correct? And I was able to ask a few questions, okay? Do they come to New Jersey to perform work? Where's their base of operations? Where do they report into? Where is their supervisor located? Okay? Where do they submit their work product to? If the answer to all those is New Jersey, the law applies, even though they're one employee in another state. Okay? So things we have to think of because we don't want to run afoul of this law because we could be sued, right? The employer could be sued. So very quickly, what does it provide? Up to 12 weeks and a 24-month period. Please note that. Under federal law, it's 12 weeks within a 12-month period. Yes, 12-month period, they get 12 weeks. State law, they get 12 weeks every 24 months. So we want to make sure we have documentation on the leave. We know how much time they've taken. So if that employee comes to you 18 months from now looking for the same leave, you can go back in your records and say, well, how much have they taken, not within the last year, but within the last 24 months? And that's going to tell you if they have any of the 12 weeks remaining or if they've used it. Big issue here that was also changed in the law in 2019. We can no longer, as employers, require the employees to use their vacation and sick leave while on an NJFLA absence. Rather, they have the right to elect to use that time. So you really want to look at your policy, you want to look at your handbook, you want to make sure you're giving them the right to elect to use versus requiring them to use it while on NJFLA. But while you're doing that, take a look at what your policy is under the FMLA, the federal law, because under the federal law, you can require them to use their vacation or sick leave. So different standards. What a lot of our clients though have done is they've decided, you know what, we're just going to let the folks elect to use it, whether it's FMLA or whether it's NJFLA, because if while on leave, they go to the state and they seek New Jersey family leave insurance benefits, the law says if they get that benefit, you as the employer can't require that they use their sick or vacation time. They just have the right to elect the time. So to make things easy on themselves, a lot of employers have just gone to a unilateral policy and said, if you're on FMLA or NJFLA, we're going to let you elect to use your time. We're not going to require it. It's a business decision, but something I just wanted to earmark. You'll see our second CLE code at the bottom of this slide, HR 0321. Again, for those who may not see the slide but are listening by phone, second and last CLE code, HR 0321. Okay, so as I wrap up here to come in right on time, what can this leave be taken for? And I list some of the things here on the screen. I just want to point out what I haven't read. Okay, this is leave for a family member. And the definition of family member under New Jersey law is very broad. It would include a child, a spouse, a parent-in-law, and it's in red because the federal law doesn't cover parent-in-laws, but state does. Your partner in a civil union, and look at the bottom of the screen. It's also a sibling, a grandparent, grandchild, domestic partner, or any other individual related by blood to that employee, or anyone that shows we have a close association with that person. That's the equivalent of a family member. Very broad. So if someone comes to you with this request, my family member has COVID, I need to care for them. Well, who's your family member? Well, really it's my next door neighbor, but they're like an aunt to me, and they're 90 years old, and they've always looked to me for their care, and I really need to be there to care for them, and I want to take this leave. You know what? Probably a valid request, and your management team needs to know what this very broad definition is. But the other one I really want everyone to focus on is this item number 4. This is new. This came about due to the pandemic. So instances when a state of emergency is declared regarding an epidemic or a communicable disease, that does a couple things. 1, requires in-home care or treatment of a child due to closure of the school or care of their by a public official. It's closed. So different from school is open, but the parents have the option of doing virtual learning. School's not closed, school's open. So for this, the school has to be closed. Okay? Or number 2, prompts a public health authority to require certain measures as a result of a communicable disease because the presence of a family member in need of care in the community would jeopardize the health of others. Or 3, results in a healthcare provider or public health authority recommending that a family member in need of care by the employee voluntarily undergo self-quarantine. So if your employees come to you with any of these requests for any of these reasons, please remember the slide and think, okay, now we have to determine, does the NJFLA apply to us as a company? If so, is this person eligible? Have they been here a year? And have they worked 1,000 hours in that year? Number 3, If yes, have they taken any of their NJFLA time in the last 24 months? Go back and look in your records. If this person's been out before and they've used all 12 weeks, they have nothing left, right? At this time, right? They have to wait 24 months from when they last were on leave. So these are the checklist items that we really have to consider. Now, very briefly, I mentioned here the Families First Coronavirus Response Act in the blue note at the bottom. That was the law that went into effect on a federal level April 1 of last year, which provided people with 80 hours of paid sick leave, and it also allowed folks to have expanded FMLA rights if the school was closed and they needed to care for their child because the child was home alone otherwise. So this FFCRA benefit applies to employers with less than 500 employees, and it expired December 31st on its own terms. Expired. The mandate expired. The mandate remains expired. However, Congress allowed employers to voluntarily extend the benefit to March 31st of this year and continue to get the tax credit from the federal government. We say, all right, well, that's 2 weeks away from that. Well, according to the American Rescue Plan that the president signed last Thursday, March 11th, they have further extended an employer's right to voluntarily extend the FFCRA leave from March 31st to September 30. Again, it's on a voluntary basis. Do you need to do this? No, it's purely voluntary. But if you do it for one, you really have to do it for all so that you avoid any type of discrimination claim by an employee who's been denied any leave under the FFCRA. So interesting development. I wanted to bring everyone aware of it. It is a very recent development, and we're getting a ton of questions from our clients about how this actually works and when the benefit will run through. Okay, as I wrap up here, the leave may be taken consecutively or intermittently. On the intermittent basis, they no longer need your approval. In the past, they would have to request to take NJFLA leave intermittently, no more. They could just come to you and say, this is what I would like to do. And the employer cannot really object to that if it's a valid basis. Okay. Do employees get any money when they're on NJFLA? Well, not from the statute. Remember, this is Railroad Track 1. This is just leave. But while they're on this leave, they can come to the state on Railroad Track 2 and seek the New Jersey Family Leave Insurance benefit. That's where the money may come from. But again, it comes from the state. It doesn't come from your business. This is purely unpaid leave. Do you have to hold their job open, though? And do they have job restoration rights following that leave? Yes. Okay. They have to be returned to the same or substantially equivalent position with the same rate of pay and the same benefits. And my last slide, we get asked all the time by employers, are there forms that we could fill out? I'm on the state's website. Employers tell me all the time, I can't find anything, any forms to be filled out by us or by the employee when they need NJFLA leave. Well, you know what? You're right. There are no forms that the state has put out for purposes of the NJFLA. Now you may say, well, wait a minute, I've seen forms before for people on leave. Yes, you're probably thinking under the federal FMLA, the federal government has excellent forms on their website. Okay? For the NJFLA, the state has nothing. There are no forms. So there's no government issued form. So what we've done with our clients is we've helped them create a form that they can use to administer the leave, to document the employee's use. It explains the employee's rights and responsibilities, and the employee will sign off on it. So now you have that very valuable documentation that you could put in their medical file to support the need for this leave, and that the employee understood what documentation may need to be provided, how much leave they have, and what their benefits will be during that leave. Okay. So at this point, what I wanted to do is right on time, maybe just 2 minutes over, I wanted to turn to any questions anyone may have. And then I know we have our networking session to follow as well. So thank you, Alice. If there are any questions, be happy to field them.
Okay, Mike, there is one in the chat. Came in a little bit earlier in the presentation related to returning back into the office. What if we want to have someone come back into the office, but they state that they don't feel they should have to since COVID proved they can get the job done remotely?
Yeah.
Also, if they say they don't feel safe in the office, but post pictures on Facebook of themselves not wearing a mask and in big groups.
I would love to say that's a unique question. I can tell you it is not. We field that from hundreds of employers. Very, very common. People have gotten used to working from home. The reality is, unless, if as people come back to the workplace, unless they have a valid reason to be out of work, like they have a medical condition and you're accommodating them under the ADA or the LAD to work from home, that's an accommodation. Okay. If they're unvaccinated, right? And you do your analysis that we spoke about and you determine they're a direct threat and therefore they're going to work from home. That's a valid reason. But to say I'm afraid, to say I'm not comfortable, that alone, standing alone, is not an acceptable legal reason for the person not to come back. What we're explaining to our clients who have that question is you may want to, and you may have done this already, whoever asked the question, but you may want to educate the workforce. And I say you do that in a couple ways. One, your COVID policy. Your COVID policy is going to explain all that you're doing to create a healthy, safe working environment, your health screening protocol. It should alleviate people's fears to think, oh my God, I've been out of work for a year and I don't know what's happening there and I'm going to go in there and I'm going to die. You've been taking precautions. They need to understand what you've been doing, and it's an educational session. So you may even, a lot of employers have had Zoom meetings to say to everyone, folks, I want you to know your health and safety is our top priority. And this is what we're doing to create a safe environment. We've been doing it for a year. We have it down pat now. And these are our expectations and these are our policies. And maybe even use that educational little meeting to go over your COVID policy with everyone so that they understand.
Okay. Mike, a quick follow-up to that. If an employer has a scenario in which, you know, post this epidemic and we're returning back into the office, but feel that a portion of their workforce could stay fully remote, and so you're making choices of certain positions need to be on site and other positions do not. Anything to think about related to making sure it doesn't appear discriminatory how you're deciding who you need in the office and who may stay remote?
Yeah, great question. Again, thank you for the question. I would do it by purely on job responsibilities and position, meaning no names. This isn't an individualized assessment. Well, John could do this, Mary could do that, and Joanne could do that. No names, no people. It's the job duties and responsibilities that you're analyzing. And then all the people who fit into that job duty or responsibility, let's say you decide all of the sales team, I'm making this up, can work remotely, then it would apply to everybody, right? So you don't want to have the older, in quotes, sales members be working from home because maybe it's a little unsafe for them, but everyone else, you younger folks, you need to get in here. That's based on age. So we don't want to make these decisions based on any protected class, age, race, religion, national origin, disability, marital status. It's based on the duties to be performed, and then treat everybody in a uniform fashion.
Okay, great, thanks. So it doesn't look like there's any additional questions in the chat, so might be a great idea to get started with our networking.
Great.
Okay, so Jasmine's going to place you in 2 rounds of breakout rooms, each for 10 minutes. Actually, it's gonna be less than that, but for a few minutes. Please take the time to network with Mike and with your peers. Clock will appear when the first session is ending. All you need to do is say yes if you do see the clock, and you'll be directed to the next room. All right, so we'll see you in a minute.